Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Patricia Kane. Patricia is a professor of law at Santa Clara University. She's been teaching law for over 36 years, and I still think I'm talking about somebody else. Anyway, she briefly practiced law before she became a professor, a member of the Texas and Iowa bars, and provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. Today we're going to be talking about estate and gift tax problems of same-sex couples, mostly focusing on California law because Patricia and I both basically are headquartered here in California. I'm in San Jose, she's in Santa Clara. But many of the problems that we're going to be talking about are shared by unmarried couples, and so that might interest you as well. And also I'm going to call her just Pat. So anyway, that's how we usually talk. And before I get started, again, caution you, we are discussing issues in a very complex area. I view this as a starting point for a bigger discussion that you should have with your tax advisors, your attorney, your CPA, enrolled agent, financial planner. Get qualified legal and tax advice. Also, as I said, mostly we're talking about federal and California standpoints, and California is a community property state. That's extremely important for what we're talking about here, and viewers in other states need to seek advice about their local laws. So with that, Patricia, thank you for joining me today.
Thank you. Good to be here.
Off we go. So, again, to let you folks know, today is February 8th, 2011. Last May of 2010, the IRS issued a chief counsel advice that said community property tax rules would apply to same-sex registered domestic partners. Can you explain the basic concept behind that rule?
The rule is really based on case law. It goes back to the year 1930 and the decision in Poe versus Seaborn, where the U.S. Supreme Court said that community property laws in the community property states would be recognized for tax purposes as though all income that was community income immediately vested in each of the two spouses. So for example, if you have a husband who was making $100,000 and his wife made nothing, the tax law would view him as making $50,000 and her as making $50,000. And all property that they acquired would be owned 50-50 by each of them. That's very different from other states like Georgia, or Iowa, Massachusetts. Those are common law property states. And there, a husband making $100,000, it's all his income, and anything he buys with it, he probably titles in his own name, so it's all his property. So it's a splitting of income and a splitting of property under state rule, community property. And now that applies to same-sex registered domestic partners, opposite-sex registered domestic partners, same-sex married couples in California, whether they were married before Prop 8 or even after Prop 8, so long as they were married in a jurisdiction where their marriage is legal. So for the first time, we have community property rules being recognized for tax purposes on couples who are not recognized as married for federal tax purposes. That makes it a little unique.
Yes. And so, but what we're saying then is that basically state laws related to property rights control for certain tax results.
Right. I mean, it's not unlike recognizing a joint tenancy or a tenancy in common. Mm-hmm. Once you own property jointly, tax law recognizes that state property law that gives you the rights. The only thing that's different is that for community property, the income, when it's earned, even earned income, not just income from property, but earned income, is viewed by the tax law as earned, or as owned 50% by each spouse.
Okay. Now, let's say one partner has substantial earnings, and so now it's community earnings, and they go out and they buy property with it. So as I understand it, then that property is going to be community property owned by both.
Anything acquired during marriage other than a gift, bequest, or devise is presumptively community property. So your earnings are community, and when you buy property with those earnings, the property is community. What that does is it vests the non-wealthy spouse in 50% of the property, and it's not treated as a taxable gift for gift tax purposes. A husband in Georgia who put his wife on title, let's say, if he bought something for $100,000 with his salary, would be making a taxable gift and would probably have to file a gift tax return and pay some gift taxes on it prior to 1981. Mm-hmm. We didn't have 100% marital deduction until 1981, and so we have lots of law dealing with husbands and wives who make transfers between themselves that end up being taxable gifts.
Okay. Now, so anyway, again, no transfer because it's just by the nature of the property, you just own half of it.
Yeah,
each
because
of you.
because the only thing that vests you is the state law. So
Yeah.
so I am not willingly giving 50% of my property to my partner. The state is forcing that division the minute it is acquired.
Okay. Now, does this give? By the way, when you said marriage, that just registered domestic partners are treated the same as married couples as far as this is concerned.
Yes, registered domestic partners in California, Nevada, and the state of Washington are all subject to the community property regime in the same way that married couples have historically been subjected to those community property regimes.
Okay. Now, does this give registered domestic partners who happen to be living in a community property state an advantage over same-sex married couples or registered domestic partners in another state like Massachusetts or Iowa that recognizes registered domestic partners?
I think it does. I think the husbands and wives in the 1930s thought that they had an advantage over separate property states because the main thing was they could split their income, and we have a progressive income tax rate, so it was very beneficial to them for income tax purposes. So beneficial that non-community property states were considering switching to community property states solely for tax purposes. Pennsylvania became a community property state for 3 months before joint returns were enacted in 1948. And when joint returns were enacted in 1948, that's also when we got the concept of the marital deduction, to give the common law states the same advantage that community property states had. Well, we don't have a marital deduction if we're registered domestic partners or same-sex married because the federal law doesn't recognize our relationship. But they do recognize the community property rights. And so if I were in Georgia and I wanted to give property to my spouse or my partner, it would be a taxable gift. If I'm in Massachusetts, even that recognizes my marriage, at the federal level, it's not recognized, so any transfer would be a taxable gift. But in California, in Washington, in Nevada, the split by the community property laws evades the gift tax.
Okay.
That's a benefit. Now, mind you, it's not as much of a benefit as it used to be, because as we were just discussing, we have a new exemption for gift and estate tax of $5 million. So a lot of people aren't as concerned about the gift and estate tax laws as they used to be when the exemption was $1 million or even $3.5 million. But we don't know what's going to happen in 2 years, though. We've got a $5 million exemption for at least 2 years.
So maybe we should backtrack just a little bit. Because a lot of people just aren't familiar, or maybe they saw it in the newspaper, but it didn't register. So what happened was late, almost at the end of the year, what happened is that in the end of 2010, Congress extended the Bush tax cuts, and as part of that new law that they enacted, they had a $5 million exemption that they put in place. They extended the estate tax. We had something that was going to be called carryover basis for 2010. The estate tax was supposed to be repealed for 2010. Now we have an option for 2010, so you can either treat it as repealed with carryover basis or to use the new regime with the higher exemptions. And also a lower rate, is it 35%?
35%.
Yeah, tax rate that applies for estate tax.
And gift tax.
And gift tax. And also we reunified
Yes.
our system. So
Yes.
before we had a $1 million exemption for gift tax,
right.
while we had various
3.5,
amounts,
yeah.
got up to 3.5, and then it repealed for a year. Things have been chaotic here for the last several years, trying to figure out how we're going to plan and all this other. We didn't ever expect the estate tax to be repealed, and then we got all the way through with it, and so now they've given us this choice. But anyway, so for many people, it actually can give a lot of flexibility because they have considerably less. There's not many of us. There's not many of us.
We all hope to pay an estate tax.
Yeah, we would like
one
to.
day.
So that can make it a little more convenient. But on the other hand, particularly again, there are some people that do have substantial property and that are same-sex couples. Elton John comes to mind, and I know that there's Ellen DeGeneres. I'm sure she's got more than $5 million, and so there are a lot of these celebrities we're familiar with. There are a lot of other people who are business people and so forth that have accumulated quite a bit.
Yes.
And so for them, these things are still a concern. All right. So there's one other thing then that's in this that we were talking about a little bit before, a new feature that was adopted, and it has to do with portability. So I'll let you talk about this for a little while, and how it relates to the same-sex couples.
Well, first of all, portability is only for spouses, so it wouldn't get it. But the idea is that each person is entitled to a $5 million exemption, and people often shorthand say, well, that means a married couple has a $10 million exemption. Of course, it does if they have the estate split $5 million each,
yes.
Which in community property states is likely. And for same-sex couples who are subject to community property regimes, a split of $5 million each is likely. But a lot of people, one spouse has accumulated all of the wealth, and if that spouse dies first and leaves everything to his spouse, he gets a marital deduction. Mm-hmm. He didn't use his exemption. So if they didn't do any estate planning, they'll find out they're going to end up paying too much in tax per couple. Mm-hmm. So the idea was if the first spouse dies and hasn't used up his exemption because he didn't need it, then the surviving spouse can add that to her exemption and claim the full $10 million when she dies. It really is a fix for people who didn't bother to plan their estates in advance and make sure that each of them got their $5 million exemption. But as I said, as with so many other things in the tax law, it's only available for spouses, and so long as DOMA is on the books, the Federal Defense of Marriage Act, same-sex couples cannot claim any of the benefits that are available for spouses, even if they are spouses under state law.
Now, this could be one of the reasons, again, why people are saying that the law is actually unconstitutional.
Absolutely. I mean, the marital deduction is the best example. If a couple really is an economic unit, when the first person dies and leaves everything to the surviving spouse, maybe they have a $10 million home. That may seem like a castle to us, but to them it was their home.
Yes.
And if the first spouse dies, we don't want to charge estate. They shouldn't have to sell the surviving spouse shouldn't have to sell the home.
Yeah.
In order to pay the estate taxes.
Yes.
But if they're a same-sex couple, they would have to because they aren't entitled to the marital deduction. There is, in fact, a case now in federal court challenging the Defense of Marriage Act on the basis of the marital deduction, on the basis that the surviving spouse ends up with a lower estate because she could not claim the marital deduction upon the death of the first spouse. We don't have an opinion in that case yet. It's in the Second Circuit, whereas the case that's already progressing through is in the First Circuit, dealing with income tax issues. But this is an estate tax issue. Yeah. That's in front of the federal courts now. So it'll be interesting to see how that case turns out.
Yeah, so there's a number of, that's part of the reason for having a